Hello, my name is David Petrosky. Today I'm going to be discussing a new law that was just passed by the California government and signed into law by Governor Newsom. It's known as AB3088, or the COVID-19 Tenant Relief Act of 2020. Keep in mind that I'm only going to be discussing some of the main points of the new law and as it relates to evictions. There are several areas of the law that I'm not going to be discussing. Please also keep in mind that this information is only general information, is not intended to be legal advice, and is not legal advice. Everyone should contact their own legal counsel before taking any action. Similarly, the laws continue to change. This video may not be updated to reflect future changes in the law. Let's get started. Under the COVID-19 Tenant Relief Act of 2020, there are several important dates that you as a landlord need to be aware of, and it's defined in the law itself. The covered time period is the period of March 1st, 2020 to January 31st, 2021. That's the period of time that this law covers. You have to further break it down into two additional time periods. From March 1st, 2020 to August 31st, 2020 is known as the quote-unquote protected time period under the law. As for the September 1st, 2020 to January 31st, 2021 time period, that's known as the transition time period. It's important for landlords to make that distinction between those two time periods because the law requires different things depending on the time period covered. So let's dive into the first period of time, which is known as the protected time period. And again, that's March 1st, 2020 to August 31st, 2020. If a landlord is going to evict a tenant or attempt to evict a tenant for non-payment of rent, instead of the normal rule, which would be a 3-day notice to pay rent or quit, AB3088 requires the landlord to create and serve a 15-day notice to pay rent or quit, and the notice must include certain information on it in order to be valid. In addition to that, the state of California requires with that 15-day notice that landlords include a notice from the state of California and its specific language that the state requires. In addition to that, landlords must also include what's considered an unsigned declaration. So 3 things: the 15-day notice to pay rent or quit, the required notice from the state of California, and the unsigned declaration. Now, once the landlord serves that notice on the tenant could do a couple of different things. They could pay the rent that's demanded under the 15-day notice. They could not pay the rent, but they could sign and return that unsigned declaration, which really tells the landlord that the tenant has been impacted by COVID-19, and that's why they're unable to pay all or some of their rent right now. If the tenant signs and returns that declaration to the landlord within the 15-day period, then the tenant is protected from eviction forever. If the tenant doesn't pay the rent demanded under the 15-day notice and fails to return the signed declaration. So essentially, if the landlord gives the tenant the 15-day notice and the tenant does nothing, doesn't pay the rent, doesn't return the declaration, essentially ignores the notice completely. Well, then, beginning in October 2020, the landlord would be able to file an eviction case against the tenant in court. However, there is what's known as a backstop, and landlords need to be very cautious about this because even if the tenant fails to return that 15-day notice unsigned declaration to the landlord, the tenant has the right to come into court at a future date after the eviction case has been initiated, file a motion, tell the judge that they didn't know what the rules were or that it was their mistake, or inadvertence, and then the court would dismiss the eviction. Even though the landlord has spent time and money on the case, the court would dismiss the case. So do keep that in mind, that even if the tenant doesn't return that declaration to the landlord within the time period prescribed under law, the tenant could still potentially get out of the case. Now, if the tenant does sign and return that declaration to the landlord, then at that point, the landlord can never sue the tenant for an eviction case with respect to that unpaid rent. But what the landlord would be able to do is take the tenant to small claims court beginning in March 2021. But again, it would not be grounds for an eviction. It would be grounds only for a small claims court case. So yes, the tenant still owes the money that's incurred during this period of time. But if the tenant signs that declaration, the landlord would not be able to evict the tenant in the future. They'd only be able to go to small claims court. And again, that would be beginning in March of 2021. Now let's switch gears and talk about the transition time period, which is September 1st, 2020 to January 31st, 2021. A lot of the same requirements apply here as they do with the protected time period. For example, you still have to give the tenant a 15-day notice with a required state of California notification that's a different notification than for the protected time period. You still have to include the unsigned declaration. There's one additional step, though, for the tenants. The tenant has to pay by January 31st, 2021, 25% of the rent that was incurred between September and January of 2021. So what does that mean? Well, it means if the tenant gives the landlord that declaration, they sign it and return it to the landlord, then the eviction case is on hold, and the tenant has until January 31st, 2021 to pay 25% of the rent that's incurred during that time. The tenant doesn't have to pay 25% each month, meaning they don't have to pay 25% in September, 25% in October, and so on and so forth. They only have to pay that 25% by January 31st, 2021. So for example purposes, if the rent was $1,000 a month, 25% of that is $250. If the tenant does not pay the rent between September and January, that's 5 months. 5 months times $250 is $1,250. So by January 31st, 2021, the tenant would have to pay $1,250 under that example. And if they do that, then they are protected from an eviction. The landlord would be able to take the tenant to small claims court, again, just like I was mentioning before, in March of 2021. But if the tenant doesn't pay that 25% by January 31st, 2021, then the landlord would be able to begin the eviction case for the non-payment of rent for that 25% beginning in February 2021. So I've talked about non-payment of rent issues. Now I'm going to briefly talk about other issues that are not related to non-payment of rent, such as causing a nuisance at the property, having unauthorized occupants at the property, damaging the property, so on and so forth. Under AB3088, evictions that are unrelated to non-payment of rent can move forward, but the landlord must have what's known as just cause, and just cause is defined in the law. But to give you an example, prior to this AB 3088, there were a lot of times when a landlord could simply give the tenant a 30 or a 60-day notice to terminate a month-to-month tenancy without listing any cause. But now under this rule that's in effect from March 2020 through January 31st, 2021, that's no longer the case. In order to terminate a tenancy, all landlords must have and list a just cause reason for the eviction. Few important things to note. In counting the 15-day period, weekends and judicial holidays are not counted. In addition to that, if your tenant owes any past due rent for the protected time period, which is March 1st, 2020 through August 31st, 2021, the state of California requires the landlord to provide the tenant with a required form by September 30th of 2020. That notice lays out what the tenants' rights are during this time period. And again, landlords are required to give this notice to tenants by September 30th if the tenant owes rent between March and August. In addition to that, there is a provision in the law for high-income tenants as defined in the law, and if the tenant is considered a high-income tenant as defined, then the landlord can request that the tenant provide documentation to support the tenant's claim that they have been impacted by COVID-19 financially. If the tenant is not high income, however, the landlord is unable to demand any documentation. The landlord must simply rely on the tenant's signed declaration. In addition to that, any 3-day notices to pay rent or quit, or 30 or 60-day notices that were served between March and January 2021 that were without cause listed are no longer valid. They would need to be reserved. Again, 3-day notices can't be used at all for non-payment of rent. It's a 15-day notice. In addition, if your local city or county has eviction restrictions currently in effect, those are grandfathered in. So you'd want to make sure and check whether or not your local city or county has any eviction restrictions, because those need to be abided by. And then these rules that are in effect due to AB3088 are currently set to expire for the most part at the end of January. So beginning in February, if the legislature doesn't do something to change or extend this rule, beginning February 2021, the normal rules kick into effect again. So 3-day notices for non-payment of rent, 30 or 60-day notices without just cause if you meet the exception to the just cause requirements. So keep that in mind. This law is meant to go away after several months, in which case the old rules would again become applicable. For more information, go to our website, which is attorneydavid.com. There is a lot of information on landlord eviction cases on the website. I publish a blog with a lot of helpful information for landlords. Follow us on Facebook or Twitter or both. I do publish updates on eviction rules in California on a regular basis. And if you have specific questions and you want answers to your particular case or potential case, we do offer paid consultations. So go onto our website, attorneydavid.com. There's a contact form on there. You can schedule either a paid 15 or 30-minute consultation, and we're happy to discuss your specific case. Thank you so much.